Hi everyone, Attorney Knighton here of Sterling Law Offices, and today I'm going to talk about secrets of a guardian ad litem. A guardian ad litem is an attorney that is appointed by the judge to represent the best interests of the children who are going through custody and placement disagreement with their parents. The guardian ad litem is supposed to investigate the facts, participate in negotiations, and then take a position in court on what custody and placement should be. The guardian ad litem can also get involved with financial issues such as child support and child expenses if there's no agreement. So here's a little bit more you need to know about a guardian ad litem. First, the guardian ad litem does not have any of the rights or duties of a parent. Although the guardian ad litem sometimes is referred to as a children's attorney, really their role is to advocate for the best interests of the child, which may be different from what the child even wants. A guardian ad litem becomes involved when the parents cannot agree on custody or placement. Typically, the courts must first try mediation, and when that becomes unsuccessful, the court appoints a guardian ad litem to do an investigation. Normally, the guardian ad litem is appointed by a court commissioner or a judge, but sometimes parties know right away that they're not going to be able to reach an agreement, and parties request that a guardian ad litem gets appointed rather than going through mediation. The guardian ad litem investigates facts that are relevant to the issues in the case, and those are normally identified in the statute. And they may start with informal discovery by interviewing parents, the children, and anyone else who has a significant relationship with the child and see the child with their parent. But then they can start doing more formal discovery by asking for records, such as medical records, school records, or mental health records. They may also do things called requests for production of documents, depositions, and interrogatories. And your attorney can kind of talk you through each of those formal discoveries. Typically, the guardian ad litem will tell the parents, and if they have attorneys, their attorneys, what they're going to present to the judge as far as a recommendation of what facts or evidence they uncovered during their investigation. And after the parties have that information, the parties can decide if they want to reach an agreement, either accepting what the guardian ad litem is going to suggest or making some tweaks that the guardian ad litem can agree to. The guardian ad litem's appointment generally ends once the case is resolved through an agreement, or there's a hearing where the judge ultimately makes a final decision, but does listen and weigh heavily the recommendation of the guardian ad litem. In the end, both parties typically are responsible for the guardian ad litem fees. So if you are considering whether or not a guardian ad litem will be involved in your case, it typically happens after mediation fails. And again, they represent the best interests of your child, not exactly what your child wants. If you have more questions about custody and placement or the role of the guardian ad litem, we have lots of resources, blogs, and tools on our website. Visit us at www.sterlinglawyers.com, and I'll see you next time.